Turning to some of your legal questions now with our Fox 26 senior legal analyst, Chris Tritico. Chris, good morning. Good to see you.
Good morning.
Let's start with Pamela. This is our first question. So Pamela writes to us, my mother moved into what was at the time an independent living apartment for seniors. It's now a nursing home. She has a lease, and as far as I know, there is nothing in it that makes it different from any other apartment complex. However, they require residents and guests to check in and out every time they come or go. This includes the taking of temperatures and requiring a mask. The governor has lifted the mask mandate, so is it legal for them to continue doing this?
Well, it depends on what your lease says. In an independent living center or any apartment complex, they can have rules that require people to sign in and sign out if that's what you agreed to when you moved in. And I'm not sure what your lease says or what the rules of this apartment complex are. At many high-end apartment complexes, they have a sign in, sign out policy just for the protection of the residents. And so you need to check the rules that you agreed to when you signed your lease. As far as the mask policy goes, when the governor lifted the order and said that people could no longer had to wear their masks, that does not affect private property. And private property owners have the right to insist that people wear masks on their property. And so that mask order the governor signed doesn't affect that private property interest that the landowner has in his property. And so I'm not concerned about the mask, but you do need to check the sign in, sign out conditions of the lease or the rules of the property. Good luck.
All right, Chris, our next question comes from Pat. This question also having to do with a complex. Pat writes to us, my apartment complex sent an email stating that there is a sewer problem in our building and that they're finding feminine hygiene products, baby wipes, and paper towels in the pipes. They claim they will assess a damage fee to everyone in the building if this does not stop. So she's wondering, is this legal?
Well, that's an interesting issue. Can you assess a damage fee to everyone because one or a few people are damaging the pipes? And the answer is probably yes. They can do that because they can't necessarily identify who the culprit is. But I would check with the lawyer of your choice who handles real estate issues and property issues on that before it goes into place and see if there's something you can do about it. But my answer is I couldn't find any real guidance on it when I looked, but my answer is probably yes, they can do that just to protect their interest in all the money they're spending to get these pipes fixed continually. But check into it before it goes into effect. If you're not happy with that complex, when your lease is up, there's plenty of them around. Good luck.
Well, that's unfortunate, right? I mean, those pipes are sensitive. Everybody just know that, right? Okay. And our final question today, Chris, comes from an unhappy camper. So this person writes to us, we purchased a new RV in 2019 with an extended warranty. We're having issues with the flooring inside the camper. We were told to take it to an RV dealership that does warranty work. We were told at the time that this would probably not be covered because it is cosmetic. The dealership told us that the floor had previously been repaired. But we purchased a brand new RV, and this is what we were told we got. No one told us about previous repairs. They also told us that the manufacturer has a record of the floor repair. The cost to repair the floor is about $3,000. Do we have any recourse?
Well, so there's several issues here. First, you need to look closely at the extended warranty to determine if it truly doesn't cover this issue. The fact that they say it doesn't cover it doesn't necessarily mean that it doesn't cover it, because they're always looking for ways not to pay. That's kind of the way insurance works sometimes, unfortunately. Now, with respect to whether or not you bought a new RV versus one that had been previously damaged, this could be what we call a deceptive trade practice. They sold you something as new that was in fact used. And so I want you to consult with the lawyer of your choice to look into this. But you need to understand that when they're selling new vehicles, they can have something that was damaged in the process of transportation from the manufacturer to the dealer, repair it before it goes into service, and still sell it as new. And that doesn't make it a used vehicle. And so that's what you need to be careful about before you go into litigation. And your lawyer will know all these things. So look into this. You may have, in fact, bought a new vehicle that had a minor repair work and still it's still a new vehicle. So check into all this and see. You may be able to sue them. You may be able to get your money back for the repairs. I just don't know enough yet. Somebody needs to look into it, but you may have a Deceptive Trade Practices Act case. If that's the case, you can get 3 times your damages plus attorney's fees. Good luck.
All right, Chris, good questions today and good advice. Appreciate it. Have a good rest of your week. We'll see you soon.
All right, you too.
And as always, if you have a legal question, you can hop on our website, fox26houston.com, find Chris's segments under the morning news tab and send it to us. As always, for specific information and advice, be sure to contact the attorney of your choice.